Alright, what's up with it, y'all? So look, man, I'm back again with another video, and I'm pretty sure some of y'all have already seen that ATK Scotty was found guilty, but they just found Ksoo guilty as well. Now, I know a lot of my people over here don't know who the hell I'm talking about or what the hell I'm talking about because we don't be on this type of time, but I am going to start bringing certain things to the channel so y'all get used to this. You feel me? This if you rocking with me. Now, if you do want me to continue dropping like videos like this, make sure y'all hitting that like button and leaving a comment here and there so I kind of get the idea of what I really want and things like that. But ultimately, I know my real supporters rocking with me on whatever I post, so it is what it is. But let's go ahead and move forward. So look, Ksoo was found guilty, right? I already knew that he was going to be found guilty after they found ATK Scotty guilty. But listen, the things that Ksoo had over him, I feel like he was going to be found guilty. It was inevitable. Now, I thought he had a fighting chance with at least one juror, but he did not. All 12 jurors unanimously decided that he was guilty. Now, he had 5 to 6 things that just surface level things that he had going against him, right? The main thing was his daddy testifying against him with his little hoe ass. Now, like I said before, and I'm gonna continue saying, I feel like that if he gonna testify, it should have been if he didn't know nothing about nothing and didn't have any parts of anything, and he was brought into something unknowingly, but he knew exactly what the hell was going on from beginning to the end. He played his part, and I feel like he shouldn't have had an opportunity to testify, but they needed his testimony to get Ksoo, so that's understandable. He also had the other driver that was alleged to be the getaway driver in another murder, you know what I'm saying? And I mean, you got too many things going against you. You had DNA evidence in the car, DNA evidence on the shirt, 2 testimonies going against you, DNA evidence on a firearm and things like that. Now, he do have a good chance at a appeal, but it's gonna be a long process when it comes to shit like that. I just feel like when it comes to these type of situations, man, it's inevitable for you to get caught when you are involving multiple people in this type of shit. Ksoo rapped about a lot of stuff. Even if he didn't do what he was rapping about, it aligns with so much different shit to the point where they're gonna feel like, okay, he did this shit. You feel me? But look, I do have the opening statements from his lawyer. So listen, this is the sequence of the events that y'all about to watch right now. What y'all about to watch right now after I get through talking is the judge and the jurors and everybody, finding him guilty and things like that. The video that comes up after that was the opening statements. That what kind of gave me a little bit like of a thought that he was going to possibly have a good chance at least some of the jurors riding with him. I feel like he was going to be found guilty anyway because he had so much shit going against him. But at the same time, I thought he had some type of fighting chance because of the opening statements and shit like that. So I'm gonna let y'all listen to that. Also, I got the closing statements coming after the opening statements, which was today. So the opening statements was the other day. The closing statements was today. So look, I'm gonna let y'all watch this. If you're on the road or something like that, this is perfect for you. You can sit back, relax, listen to all of this shit that they got to say about everything. Now, as far as the snitches and shit like that, I probably put something together about them a little bit later, but I want y'all to hear the arguing statements that his lawyers had and shit like that when it comes to this trial. We heard the daddy speak with his little hoe ass. Now I want y'all to hear everybody else that's associated with the whole situation on the defense side. Now, ATK Scotty, shit, it is what it is with him, but Ksoo has a whole nother murder that he is about to be facing pretty soon. I don't know what's going to go on with that. I don't know if he's going to be found innocent or guilty when it comes to that whole situation. But, as far as like capital murder and shit like that, boy, they're going to try to give you life. They're going to try to give you the D penalty. Y'all already know how I go when it comes to shit like that. But look, I done say what I had to say about everything else. Y'all get in that comment section, hit that link and get y'all some tickets so y'all can go ahead and jump into the sweepstakes if y'all want to take a chance and win in the vehicle. If not, I'll holler at y'all later anyway it go. But yeah, y'all jump down there, click that link, and we're going to talk about everything in the comment section. RIP to everybody who lost their lives in these situations. Other than that, I didn't say what I had to say. So yeah, let me know your thoughts and opinions, and we're gonna talk in the comment section.
Robinson, his counsel. Well, you need counsel for the state. All right, we are present now with Mr. Robinson, his counsel, and counsel for the state. I'm advised the jury has reached a verdict. Any reason we can't bring the jury out now and receive the verdict?
No.
All right, let's please bring the jury out. Thank you.
Your Honor, the jury's entered the courtroom.
All right, ladies and gentlemen, you may take your seats. And ma'am, juror number 3, are you the foreperson? And has this jury reached a verdict?
Yes, we have.
Can you please hand the verdict form to the bailiff? All right, the court finds that there are no errors or omissions in the filling out of the verdict form. Madam Clerk, can you please publish the verdict?
In the Circuit of the 4th Judicial Circuit in and for Duval County, Florida, case number 16, 2020, CF 3601B, Division CRE. State of Florida versus Hakeem Robinson, verdict as to count 1, we the jury found the defendant guilty of first-degree murder as charged in the indictment. So say we all, done, Jacksonville, Duval County, Florida, signed by the foreperson on July 31st, 2025.
Does counsel for either the state or defense desire the jury to be polled?
Yes, Your Honor.
All right, Madam Clerk, if you can please poll each juror.
Juror 1, is this your true and correct verdict? Juror 2, is this your true and correct verdict?
Yes.
Juror 3, is this your true and correct verdict?
Yes.
Juror 4, is this your true and correct verdict?
Yes.
Juror 5, is this your true and correct verdict?
Yes.
Juror 6, this your true and correct verdict?
Yes.
Juror 7, this your true and correct verdict? Juror 8, this your true and correct verdict?
Yes.
Juror 9, this your true and correct verdict? Juror 10, this your true and correct verdict? Juror 11, this your true and correct verdict? Juror 12, this your true and correct verdict? Thank you.
All right, ladies and gentlemen, I wish to thank you for your time and your consideration of this case. I also wish to advise you of some very special privileges to be enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in that jury room except by court order. For many centuries, our society has relied upon juries for the consideration of difficult cases. And we have recognized for hundreds of years that a jury's deliberations, their discussions, and their votes should remain their private affair as long as they wish it. Therefore, the law gives you this unique privilege not to speak about the jury's work. Although you are now at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, or from those who might seek to find fault with you, or from the media, from the attorneys, or elsewhere. So it will be up to you to decide whether to preserve your privacy as a juror. And with the rendering of this verdict, ladies and gentlemen, your service in this courtroom over the past 2 weeks is now concluded. And all of my prior admonitions and prohibitions against looking at the news or reading the newspaper, listening to the radio, or going on social media, or talking to anyone, or looking up anything, all of those prohibitions are now lifted. You are free to do those things if you wish. Keep in mind, folks might want to speak to you, and you are free to speak to them. But again, you are also free to refuse to speak to them. I do want to thank you sincerely for answering your jury summons, coming to the courthouse 2 Mondays ago, and being part of the administration of justice. I say this every week when I have jury trials. Our system of justice, I believe, is the best system of justice in the world, and it wouldn't operate in the manner and method in which it does without citizens such as you who take the time, the consideration, and out your private lives to come down here to be part of our process. So I do sincerely and genuinely thank you. And at this time, ladies and gentlemen, you are now excused and free to go. All right, that jury has exited the courtroom. Of course, they need to cross over and exit through the other door, but until and before they do come out, counsel, if you will present your client before the bench. All right, Mr. Robinson, based on the verdict of the jury finding you guilty of the offense charged in the indictment in case number 2020 CF 3601, the court does hereby remand you to the custody of the Jacksonville Sheriff's Office, and your bond in this matter shall be revoked. Now, he is entitled to a pre-sentence investigation report, is that correct? Okay, then I will be sure to order one. Again, that takes approximately 30 days to complete, so we'll need to come back for sentencing no earlier than 30 days. When would the parties wish to return? I have the week of August 25 or September 2 for sentencing to be set.
We would request the week of the 8th.
The same week as Mr. Whitaker? Okay. Are you all available to return the week of September 8th? Keep in mind, Monday would be a to-be-set date, and we would set the sentencing on a convenient day that week for all parties involved.
I'm sure I can have, if there's anything I'm scheduling in my own.
Okay. And on the 8th, you all are free to appear via Zoom. That's just a scheduling date. That won't be the sentencing date. We'll pick a date on the 8th. All right. Then we'll pass Mr. Robinson's case to September 8 for sentencing to be set. All right, thank you. All right, everyone is excused and free to go. I'll wait for the jury to leave. All right, the jury is now out of the courtroom. Anything we need to take up before we recess? Okay. All right, thank you all. We'll be in recess.
May it please the court,
Yes.
opposing counsel, members of the jury. Good afternoon. This is the first opportunity that I have had to speak with you directly. So I wanted to take this opportunity to reintroduce myself to you. My name is Tara Kawas, and I, along with Christopher DeCose, we have the honor and privilege of representing Hakeem Robinson. Now, the government just got up here and told you that they're going to prove to you, beyond and to the exclusion of all reasonable doubt, that Hakeem Robinson is the person who shot and killed Charles McCormick on January 15th of 2020. But members of the jury, they are not going to be able to do that because Hakeem Robinson is innocent. And you are going to be able to see that for yourselves, that there is no way that Hakeem Robinson is the person that shot and killed Charles McCormick. In order to try and prove their case, they're going to ask you to do something that I've never seen before. They're going to ask you to not believe your eyes. They're going to ask you to ignore what you see right in front of you. Because as the government just told you, there is a video recording of this homicide, and you're going to be able to see it, and you're going to be able to watch it. You are going to see a person, someone, covered from head, or whatever's on top of his head, to toe, completely covered, chase down Charles McCormick in broad daylight and shoot him to death. And this was done in front of a bunch of witnesses. And the most important question in this case is going to be, who is the shooter? Who is the shooter? Members of the jury, that is the shooter. That is a still shot from the video that you will be presented with this during the course of this trial. And what these prosecutors are going to ask you to do is to find that Hakeem Robinson, who's clearly well above 6 feet tall and a heavier set person, and was like that 5 years ago, is that person. And it's not just that. They are going to ask you to ignore the descriptions given by each and every person that saw the shooter live. And members of the jury, these witnesses, each and every one of them are going to give you a description somewhere between 5'5" and 5'11". The other description they're going to give you, each of these witnesses that saw this person: slim, slender, thinner. And all those witnesses, they're going to ask you, the government, these unbiased civilian witnesses, discredit them. Don't believe them. They were wrong. The witnesses that they're going to ask you to believe are the ones who are actually involved in this murder. That's right. One by one, they are going to be walking them in here, some of them through that back door. Each one of them, hoping and praying to get some benefit from them. The people that hold all of the power to charge someone, to arrest someone, to drop charges. Them. All of these people are going to point the finger and go, the shooter is Hakeem. They are not going to present you one piece of reliable, direct evidence that definitively proves that Hakeem Robinson is a shooter. It's just going to be based on the lies of the people who actually committed this murder. This, members of the jury, is Hakeem Robinson. Stand up, Hakeem. He is a young, aspiring, talented musician who 5 years ago was wrenched from his family, his life, and his promising career. All because the government refused to look at literally what is right in front of them. And this is why I've asked Hakeem Robinson to stand up in front of you right now, members of the jury. Because you may not have taken too much notice over the past 3 days. Each and every time you walked into the courtroom and you left and we stood up, you didn't realize at that time how important it was to take a look at how tall Hakeem Robinson is and how big he is. But it is going to be the focal point of this trial. Because once you watch that video in the entirety, and then you look at what is standing right in front of you, and you're going to get pictures and stuff around the time that this took place. He hasn't changed, despite what Mr. Cooper is telling you. He is the same. There will be no doubt in your mind that he is not the person that shot and killed Charles McCormick. So how do we get here? You can have a seat, Hakeem. How do we get here where a clearly innocent person is being accused of a crime that he did not commit? And it boils down to perception versus reality. Because you're going to see that Hakeem Robinson, he wasn't arrested until 9 months after the murder. And none of them realized how big he is until he was arrested. But by that time, instead of admitting to the mistake that they made and pulling back and doing an investigation to find out who really did it, they doubled down. And they started to build their case and their witnesses around the idea and the belief that it was Hakeem Robinson that was the shooter. Now, on 5 years ago, January 15, 2020, right on the brink of the world shutting down, right before the COVID-19 virus, Charles McCormick woke up in the morning, headed to Employment Express Agency on Merrill Road to follow up with getting a job. Little did he know that a man named Dominique Barno, and I'm going to say this name for the first time, I'm not sure why the state didn't mention this to you, and his friend Chris Brown had been stalking Charles McCormick that day. Dominique Barno is the one who was checking his Instagram account to see if he was in town that day. Dominique Barno is the one who pulled up his address on the court clerk's website to find out where he lived. He is the one that then tried to track him down and kill him that morning. You will hear that the reason Dominique Barno decided that he wanted to have Charles McCormick killed was all because of a song that he didn't like the lyrics to. The whole story that Mr. Cooper failed to mention to you, members of the jury, is that Mr. Barno will just tell you, I just didn't like that he was singing something he didn't know about. That's the reason why Charles McCormick is dead. And this man, members of the jury, Dominique Barno, the man who planned and orchestrated the murder of Charles McCormick, is going to be the government's star witness in this case. That is the person who they cut it. And lied in official proceeding. And I'm talking about, members of the jury, you are going to hear that he lied to police officers. You are going to hear that he lied to prosecutors. You are going to hear that he lied in depositions. You're going to hear that he lied to defense attorneys. More important, you are going to hear that he took the stand in another case and lied in a hearing in front of a judge. And he's going to tell you the reason he did that, because he wanted the defendant to go free so he could kill him himself. That is their star witness who they're going to ask you to believe. This man was caught red-handed within 24 hours of the murder of Charles McCormick. And months go by of him denying his involvement. And when he realized that who they thought the shooter was, Hakeem Robinson, he pounced on it. He was like, this is how I'm going to get out of here. He decided he was going to lie to the government to get what he wanted, which is the hope of freedom. All he had to do and all he had to say was that Hakeem Robinson is the person behind that mask. And in exchange, I know Mr. Cooper was saying, oh, he's facing life, and that the judge hasn't sentenced him yet. But members of the jury, he's going to tell you. The reasons he's doing this, because before this, he was facing mandatory life in prison. He would have died in prison. And in exchange for pointing the finger at Hakeem Robinson, he is hoping to get out in 20 years. Mind you, he's already served 5 of it. So in 15 years, he is hoping to go free. And Dominic Barno, not going to be the only one. Another witness that they are going to put on this witness stand and ask you to believe, a man by the name of Abdul Robinson Sr., aka Blue. Now, Mr. Cooper got up here and told you that this man is Hakeem's father, his biological father, but the whole truth is, members of the jury, he's just Hakeem's DNA contributor. The truth is, he has 9 other children by 5 different women that we know about. He has probably fathered a significant percentage of the men or women in Duval County. He was never involved in Hakeem's early life and only came around when Hakeem started to become a little recognized, a little famous with his music, and he started to make some real money. He actually tried to become Hakeem's manager. As you will learn in this trial, in 2020, Hakeem was a local celebrity. He was a rap musician. And you're going to see that it was Blue is going to do what he's doing in this case. He uses people, and he was trying to use Hakeem. He is using the prosecutors in this case to get out of the 2 murder cases that we know that he have committed. He, just like Dominic Barno, was caught red-handed in this case. He is the person that Dominic Barno called for help to pick him and Leroy Whitaker up after they had broken into Barbara Buckley's home. But what you're also going to hear, members of the jury, and what is most important, this is not the first time that Dominic Barner and Blue have done this. That's right. Dominic Barner and Blue are co-defendants in a completely separate homicide case. They're co-defendants in that case, and they're co-defendants in this case. And you're going to learn that Blue, this ain't his first time cooperating with law enforcement. He's done that before, so he has experience. He knows that when he is in trouble and he is caught, if I say what the government wants to hear, I get out. He's done it before, and he's going to do it again in this courtroom. And what's more troubling with Blue, members of the jury, in exchange for his testimony in this case, he is hoping to get 76 months. 76 months. He's already served 60. So in less than 2 years, he is hoping to be back on the streets of Duval County. Now, Mr. Cooper just got up there and said the testimony against Hakeem being involved in this murder is going to be corroborated by reliable evidence. It is not. None of the credible, reliable evidence that he's going to bring in here says that Hakeem Robinson is the guy in that picture. Another one of the witnesses that they're going to bring in front of you, another one that was in that little diagram that they showed, Torragon Williams. And this is even worse, members of the jury, because their own lead detective is going to tell you they've known for 5 years that Torragon Williams was involved in this homicide. Dominic Barno, years ago, told them Torragon Williams was involved, but he gets a full pass. He's not walking through that door. He's walking through that door. Never been arrested, full-blown immunity for his testimony in this case. And you wonder, wait, why would that happen 5 years later? Well, that's because Torragon Williams last year got arrested for trafficking in meth. That's the first time he decided to come forward and go, hey, wait a second, I'm in trouble. Prosecutors, I think I know, I have information that you might want. And by this time, members of the jury, 4 years have passed, and this case was plastered all over the internet for anyone to look up and see what they needed to find out about what they needed to say. After he decided to give a statement against Hakeem Robinson, what do? They drop his state case. Dismissed, no action. Then the federal government decided to pick up his case. And Mr. Williams, if they call him to testify, is going to tell you, well, I'm hoping that the feds are going to be a little lenient on me because I am helping in this homicide case. Not one of their witnesses, members of the jury that take the stand, that tried to point the finger at Hakeem Robinson, Not one of them are unbiased. Each one of them that are going to walk in here have some angle. They either are trying to help themselves, to get themselves out of their trouble with the government, or something for a loved one. Each one of them that points the finger in some way, shape, or form to Hakeem Robinson is hoping to get something, and not something small, freedom. But members of the jury, what Mr. DeCosta and I are going to ask you to do is to listen to the reliable, credible witnesses in this case. Because what you will see that all the reliable witnesses say was that actually the shooter, they actually saw them with his own eyes, as I told you before. Slim, slender, 5'8" to 5'11". Some of them say 5'5" to 5'8". Notice that not once when Mr. Cooper was giving his opening statement did he give you a description. I'm having to tell you that. And I'm talking about not just civilians, I'm talking about trained police officers. We'll talk about Officer Collins, the one who took chase. You notice when Mr. Cooper was talking to you? Oh, well, he was far away. He was jumping the fence and didn't get a good look. He's getting you guys ready to make excuses for why the description does not match Hakeem Robinson, and not even close. Officer Collins is a trained police officer, been doing this for 20 years, knows how to give information like that so that other people, other officers who are listening, he knows to give reliable information. He may come up in here now, 5 years later, and try to backpedal, members of the jury. Not sure, I don't remember. But you remember what he said at the time. That's the most reliable. Before everyone realized that the descriptions, wait, they don't match. And it's not just him. It's not just Officer Collins. You're going to hear from Officer Graham, another one who saw the shooter in this case. You know what his description was? 21-year veteran with the Jacksonville Sheriff's Office, 5'8" to 5'10". Now, those are just the officers. Next, we're going to talk about the civilian witnesses. You're going to hear from Victor Kruger. Mr. Cooper mentioned him. He's the guy with the dash cam in his vehicle, the person that was probably the closest to the shooting, who, and he's right, by happenstance, just happened to have this video recording on his dash cam when this happened. But what did you not hear in the state's opening statement? Mr. Kruger gave a description. You want to know what that description was? 5'10" to 5'11", and he was thin. Clearly not Hakeem Robinson. Not the only one. Javaris Roberts, who worked in the Hibet Sports in that strip mall, described the shooter as 5'8" to 5'9", on the skinnier side. Then we've got Aber Ahmad, a woman who was in her garage having coffee in the morning, sees someone matching the shooter's description, jump a fence and walk right in front of her. She describes him as shorter than 6 feet. But the most important one, Renata Boston. If you recall when Mr. Cooper was talking, he mentioned that the shooter ran through some woods and came out on the other side, and that magically Natalie Gant was there to pick up the shooter because she knew where he was. He didn't mention what Renata Boston described the shooter to look at, because she saw him come out of the woods. Slim build, 5'8" to 5'9", between 160 to 170 pounds. That is not even close to Hakeem Robinson. Multiple independent civilian witnesses, multiple police officers, all describing someone that could not possibly be Hakeem Robinson. And all their testimony, all of them, the ones whose testimony isn't bought with a promise of freedom, they're all consistent. It's clearly not him. The only eyewitnesses that will say that the shooter is Hakeem are the ones who have cut deals with the government. And they're not going to just present these eyewitnesses to you. As Mr. Cooper said, they're going to present all this other stuff. But take a close look at the details of what they present to you. Because not one piece of that evidence is going to be direct evidence that Hakeem Robinson is a shooter. Let's start with the cell phone evidence, because it's going to be a lot. All the records that they're going to produce to you, all the cell phone records that definitively show 100% Dominique Barner using his phone, Leroy Whitaker using his phone, Abdul Robinson Jr. using his phone, Abdul Robinson Sr. using his phone. All of them are communicating with each other. You know whose phone isn't being used? Or they don't have a record of being used at all? Hakeem Robinson. Mr. Cooper just got up here and told you that he's going to try to put a phone in the possession of Hakeem Robinson, a phone number that begins with 478. You know whose phone that's registered to? Abdul Robinson Sr., aka Blues, former dead best friend. That phone is registered to his father, not to him. And you're going to see that that phone the day before was pinging in the same place that his father was. They're going to try to make you think and connect that phone to Hakeem Robinson, and they will be unable to do so. Next up, fingerprints and DNA. They're going to try to present you with DNA and fingerprint evidence trying to put Hakeem in that car on that day. But members of the jury, their own expert will tell you, their experts are going to tell you, we have no idea when that DNA was left there, or how. We have no idea how that fingerprint, when or where it got there. All that proves to you, members of the jury, is Hakeem Robinson knows Leroy Whitaker. They're cousins. They hang out together. That's a fact that we're not disputing. And what did Mr. Cooper fail to tell you? That DNA was found on a t-shirt that was in the car. It's not just Hakeem Robinson's DNA. The expert is going to tell you that it's mixed up with 3 other people that I don't know who it is that's on that shirt. Then they're going to tell you that, well, I'm going to tell you that the evidence will show that a man's DNA was found in that car. That's going to say, I don't know how my DNA got in there, but it's there. As someone that is completely disassociated with this case. All that's going to prove, members of the jury, is that Hakeem Robinson, Leroy Whitaker, Torgon Williams, they're all friends and that they know each other. He told you that car was had been reported stolen for 2 months. They had been all in and out of that car. That DNA and that fingerprint does not place him in the car on the day of the murder. You're going to hear about all of the DNA that they have been unable to identify or match with someone else. But members of the jury, what I do want you to know is, even though Hakeem hung out with all these guys and he grew up with them and stuff, Hakeem was different because he was making it. Charles McCormick, they said he put out that song. He didn't put out a song. I mean, no one knew about that song. I mean, he tried to release it. He wasn't on the level of Hakeem Robinson, AKA, you're going to hear this name a lot throughout the course of the trial, Ksoo. And what you're going to hear, members of the jury, which is going to be very important. 4 days before the murder of Charles McCormick, Hakeem Robinson was signed to a record label that gave him a $40,000 advance. 4 days before. He was making it, he was leaving, he was doing his music. All of these people, though, they wanted to be around him. They wanted to share in his fame. But Hakeem cannot be put in this just because he hung around with the wrong people and was friends with them. He is not responsible for what they did in their free time. And even the government, well, I thought the government would agree that you cannot convict someone by association. And that is true, members of the jury. Guilty by association has no place in this courtroom. Mr. Cooper also mentioned something about a social media post. But members of the jury, when you view these pieces of evidence, please take them into context. He said it happened right after he made this post, 7 days after he made this post, okay? And it's all assumption and speculation with the phrase that he used. He is trying to say that that is somehow a confession. That post didn't say, hey, I killed Charles McCormick. He's going to ask you to imply that when he mentioned that had something to do with the murder that happened before that he had nothing to do with. But members of the jury, what we are going to ask, and this is what I'm just going to ask, we are at the beginning of this case, you haven't heard any of the evidence or seen any of the evidence yet. All I ask of you, each of you, is to please just pay close attention and really listen. Because when you strip away all the evidence that isn't either bought with money or the promise of freedom, the truth is going to be staring you right in your face. Focus on the credible, reliable, unbiased testimony from the witnesses, coupled with what you can see right in front of them. More importantly, your common sense. Because that is what you will need to see the truth in this case, because it is not him, members of the jury. Mr. Cooper talked about the fact that this case is going to be a puzzle and that you'll be able to see a picture at the end. But I'm going to tell you this, members of the jury. If one piece of that puzzle doesn't fit, it is not guilty. Do not shave the pieces of those puzzles to try to force it to fit. Because when you look, you are going to see the description does not match Hakeem Robinson, not even close. Now, members of the jury, there is a reason why the framers of the Constitution, this country's Constitution, ensured that the government would not have too much control over the freedom of the citizens they are meant to protect. And that was by giving the final word, not to the court, not to the state, but to you. People are innately flawed in that they sometimes can't see the truth when it's staring them right in front of their face, or they can't admit it when they've made a mistake. You are 12 members of this community, 15 members of this community, who have promised to look at this case through fresh eyes. That is all we beg of you, to objectively look at the evidence that is presented to you in this case. Because when you listen to all the credible, reliable evidence in this case, it's only going to prove to you one thing. Hakeem Robinson is innocent. Find him not guilty. Thank you.
As you know, the state presented its closing yesterday, and at this time we'll call upon the defense for its close.
Thank you, Your Honor. The government didn't build a case. It bought one. An expensive expert, desperate snitches. But you can't buy your way past the truth. And the truth is, to quote Hakeem Robinson's sister, Blue's daughter, hell no. This is not the guy in the video. Let me walk you through some maps to explain what happened that day. Mike, if you would. So on January 15, 2020, Charles McCormick was at 7001 Merrill Road. Over at the Publix, you had Officer Jimmy Collins. At around 11 o'clock, Charles McCormick is shot and killed. The killers jump inside of the vehicle and they flee. Now, Officer Collins was fast enough, and you can see it in the dash cam video, that his car is parked down near that yellow line. He sprints. He doesn't run. His words. He sprints, gets into his cruiser, and gets behind that vehicle. And then there's a pursuit. They go out into Merrill Road, turn south, go all the way down to Townsend. Now, the first mark is where the car accident happens. A car crashes, 3 people jump out. 2 of them run south to Barbara Buckley's house. The focus for us here in our argument is the one that Officer Collins says runs westbound. Now, you heard some testimony. Officer Graham took the stand and talked to you about how he was in the area of Carlotta, saw somebody running westbound. Then, you also heard from Renata Boston, who lived at 7201 Arlington Expressway. That was also person that ran westbound. Now, an opening statement, which feels like months ago, Ms. Kawas got up here and said, watch what the government's going to do. They're going to tailor their evidence. They're not going to give it all to you. When you trust the facts of your case and you believe that the facts of your case are going to prove it beyond a reasonable doubt, you don't tailor it. You give it to the jury. As the government, you give it to the jury and let the jury decide. But that's not what we saw. Victor Kruger, he was back. He was in his vehicle. Dash cam, eerily music comes on when the shooting starts. He took the stand. The government didn't ask him for the description of the shooter. They left that out. I had to pull it out of him. I shouldn't have to do that as a defense, to pull it out of him, that what he saw was somebody that was very slight. Don't let this government get up here in their rebuttal and not answer the question to you why they didn't give that to you. Why are they tailoring it and giving you only the things that fit their case, but not those that are against it? Now, that applied to the witnesses as well, too. Jarvis Roberts, admittedly, he's far away, but he's a witness. Why did we have to call him? Jarvis, working at Hibbett Sports, that his vehicle, it's only a couple of seconds, and he sees somebody and he describes it. It doesn't fit their case, they choose not to call that witness. I agree, they don't have to call everybody, but there's a handful of eyewitnesses. His testimony took minutes. Why did we have to call it? Don't let them get up here and not answer that question. Instead, they want to focus and get into a back and forth with Mr. Roberts that he was maybe 5 yards further away than he said. Was it 25? Was it 30 yards? Meanwhile, they're overlooking the inches and pounds discrepancy in between the descriptions in their case. Now, the reason why we're bringing the defense, we shouldn't have to, bringing all of these witnesses to you, is for one simple thing. A dozen people, including police officers, are not going to consistently get it wrong. 12 people would have to be wrong, but consistent. Not tall and stocky, short and skinny. That doesn't make sense. Also, us as human beings, we understand that if somebody's running, that's going to drop their height. If they're far away, it's going to drop their height. I don't think that the people that are in the back of the courtroom are 12 inches tall. I have depth perception. I have the ability to be able to say, it's at a distance. But there are some people, when you get up over 6 feet, when you get up over 200 pounds, not a lot of human beings are that size. And you can very quickly determine that is not a normal size human being. That is not a normal size human being. Stand up again. I'm a big guy. He makes me look small. Take a seat. So, talking about the witnesses that consistently, according to the government, get it wrong and describe somebody who's short and skinny. Michael Williams, military vet, undoubtedly has training in stressful situations. He gives a description that doesn't fit their case, so they don't call him. Maybe hoping that we won't call him. Why wouldn't they call him? His testimony was minutes. But he says stuff that goes against their case, consistent with everybody else. Next, we have Renata Boston. I'm sorry, I forgot somebody, and this one's important. Tashita Saunders. She was the one that was inside of the staffing place where Charles McCormick was right before. Now, anything that I'm saying here, I beg you, ask for the transcript. Fact check everything that I'm saying.
Yeah, sustained.
You've taken copious notes. I trust you remember the testimony, and you'll be able to fact check me in your own mind against the government. Tashita Saunders got up here, and the government questioned her. How tall is the shooter? Mr. Cooper then argued in his closing argument, taller than Charles McCormick. That is not what she said. We had to bring it out of her. Ms. Kawas on cross-examination, 5'8", 5'9", skinny. It's as if the government is trying to blur the lines to increase the height of the shooter and decrease the height of my client because it's the only way they can bridge that gap. We shouldn't have to give you what is the truth of what the witnesses said. Tashita Saunders said 5'8", 5'9". Not because if you say taller than Charles McCormick, well, that could go all the way up. She put a cap on it. We shouldn't have to bring it out. Now, Renata Boston. Renata Boston was not upstairs and ran downstairs. She was sitting on a wall talking to her friends. She sees somebody come out of the woods. She also gives a description that we had to get out, which is consistent with everybody else, short and skinny, and also the same height that Tashita Saunders gave, which was 5'8" to 5'9". We shouldn't have to pull this information out. Your government should give you the objective facts and let you as the people decide. By tailoring it, they're not doing their job. Now let's talk about law enforcement. So let's talk about then Detective Collins. And let's contrast that with reasonable witnesses, objective witnesses. You remember earlier in the trial there was a couple of crime scene techs, the DNA people, the fingerprint people. That is objective evidence. Objective witnesses, when they testify, they answer the question straight. They're not trying to, find the answer. Contrast that with Officer Collins and also Officer Smith. Now, on Collins, we know, and we have the CAD notes. 5686, on his direct examination, the government got that out, that's his badge number. I'll zoom in here for you. He gives a description of 5'5" to 5'9". I don't buy it for a second that, I'm not sure. He could have just said, black male with this type sweatshirt running, unknown height. But he gave a description. Because the reason why you wouldn't do that, then if there's anybody tall, that's not the guy we're looking for. He gave the description that he had in that moment. He tried to be cagey. Compare him to how the texts were. We asked a question, the DNA expert. It could have gotten on there because of the t-shirt. Yes. Instead, him, from the very beginning of the cross-examination, he showed that he was motivated. When I asked him, and I go, you ran track and field, he paused because he knew that was going to be bad for his testimony. I then asked him, you have to think about whether you ran track and field? And then he goes, that was years ago. I'm not saying he's as fast as he was. I'm just saying that he's faster than this guy. 6'4", long legs, former runner, fit as anything as he took the stand. He wasn't given straight answers. Most importantly, we heard from Detective Smith, body cams. Where is Officer Collins' body cam that would have shown who he was chasing? At one point in his testimony, he talked about how recently he looked at the video and, he determined that he was wrong. People ask a question a lot on how wrongful convictions happen. That's how it happens. Because witnesses on the stand, Ms. Kawas and I have lived this case for years. We know the facts. And when he testified to that, you probably saw us jump up and our faces go beet red.
Your Honor, this is improper.
Yeah, sustained.
You saw the evolution of his testimony. He did what we're saying that the government is trying to do. They're trying to increase the size of the shooter to fill that gap. But what he doesn't realize is where he thinks that he's growing of the shooter, it's actually his own nose like Pinocchio. Because his lies, his attempt to lie, actually prove our point. Now the government, they showed a very small photo. This is their exhibit focused in. There's your shooter. All right, you can see right above him a black line in a window. That's Officer Collins. Now, if you toggle back and forth, you'll see that the shadow of the two is different. Now, I'm just pointing out a fact on what they didn't do. They talked about how there was a gradient at Renata Boston's home. What we don't know, and what we can't tell, is if that is perfectly flat, if there is a drop-off even of an inch from the driveway to the grass, and whether the grass is flat. I can assume the driveway is flat. But there may be a slight deviation. Now, in a case like this, an inch matters. But when you go back and forth between these two, it's important to notice that the shooter, and we'll talk about this in a moment, has something up underneath their hood. Latham testified that would add easily a couple of inches. Now, Officer Collins got up there and said that he's 6'4". He looked about that, maybe 6'3". Sometimes guys will exaggerate, round it up, round it down. When you compare the two and put them side by side, and I'll draw a line in here for the window, right? And then I'll also do it for the window on the other side. So that's our point of reference. Now, if we estimate where the top of the head of the shooter is, because of what they have up underneath their head, that brings them roughly to the chin of Officer Collins. I don't know what the length of the average human head is from the top to the bottom, but I'm thinking it's at least 8 inches, 10 inches. They were hoping you wouldn't look at this closely, that he could just come in here and go, oh, I looked at this video years later, this very grainy, difficult to see video, and you want to know what? I was wrong. He was my height. That's preposterous, and the evidence shows that that is preposterous. We also heard from Officer Graham. We had to call him. They didn't. That's a police officer. Former police officer. We had to bring him in. He's one of the 2 police officers that chased on foot the shooter. Unquestionably chased the shooter. Why are we calling that witness and why are they not? They're not calling the witness because of the height description that he gives. It conflicts with their case. It's consistent with all of the civilians that we brought in, all of the civilians that testified, and Collins. The important thing is this. Any big guy knows this. There's no way a guy that's 6'2", 6'3", 230 is going to outrun a cadet that had just gone through the academy, that is going to outrun a former track runner. That's going to be, and remember what Graham said, he was jumping fences. He was fast. They were even in their cruiser for a moment trying to chase him. He was that fast. That ain't him. Again, quote his sister, hell no. What was Hakeem Robinson like then? The government wants you to, say, well, photos didn't need to be taken. Remember, we're the ones that brought in the photographs the day before. We're the ones that had to bring that in, and we also brought in Howell. But if we look, this is when the scan was done, the big piece of the government's evidence. You see the build on Hakeem Robinson. Now, there's little point of reference here. If you put him up to, next to Miss Quas, a normal-sized human being, he's huge. But even in this, you can tell he's got a belly. He is out of shape. He is not toned. And, Your Honor, I hope that I can quote what I did the other day when I said the shooter ain't got no ass. He does. In the video that we had to enter in, from the JSO property room where they show, and it's in evidence, you can look at it, I'm not going to play it now.
I'm objecting to that.
I'm sorry, I missed what you said.
Entered into evidence is Defense Exhibit 3.
He had to enter it.
Okay, I'm going to sustain the objection.
You can review Defense Exhibit 3, our exhibit. It shows Sergeant Howell walk out. And Sergeant Howell's 6 feet tall, like 300 pounds at the time. And Hakeem Robinson is taller than him. But you'll notice something as he's walking. Now, admittedly, he's wearing slides and he's walking. But big guys know this. They waddle a little bit. You ever seen a linebacker? The way that they walk? It's not the same as somebody who is fit and who is fast like the shooter. And you can see it. He has sort of a duck waddle in the way that he walks. It's a product of having big legs and being a big guy. Now, so in our exhibit we brought forward, now the government had an issue. Because Renata Boston says the person that walked out of the woods had shoulder-length dreads. Now, the government, they showed you an exhibit when my client was getting a pedicure, not a couple days later, it was almost a week later, 5 days later. And they showed from an angle up down where the hair, and one could think that looks like hair that's down to the chin because of the perspective of it. Our exhibit, our videos, shows what his hair was like 18 hours before this crime that he's accused of. He had short hair. He did not have shoulder-length dreads. There's no question. He did not have He did not have shoulder-length dreads. He had short twists. The government, though, has tried to fix this. They brought in a photograph. Of all of the photographs on Hakeem Robinson's phone, there were thousands, over nearly 5,500 photos. They find photos of the hood. They only show you a few of them. They tailor it. But again, this supports our argument. Now first, before I get into this, you look at the music videos, you notice, your times out in public before, he's not the only one with hair. If you look at the different type hairstyles in Charles McCormick's music video, in Hakeem Robinson's music video, there's a lot of people that have long hair. But this proves a point if we jump into the details. You notice how Hakeem Robinson, because he has sort of a uniform hairstyle, that the back of the hood looks as if it's empty. Now, obviously, it's lifted up off his head, but the back, it's got just fabric. You compare that over to the shooter, that is a different head. That is a full hood. That is hair, that is something up underneath there. Not that hair. Those are not, I'll go back and forth, those are not the same heads. Mr. Cooper got up on his closing argument and he said, Hakeem Robinson is 6 feet. And again, we're talking about tailoring the evidence, trying to shrink Hakeem Robinson, trying to grow the shooter, trying to jam a square peg into a round hole. That is not what the evidence was. The evidence for his height from first Blue, are we to trust him or are we to not? Because he said 6'2", 6'3". Johnny Shipes, no motivation whatsoever, not in handcuffs, not looking at prison. He said, I'm 6 feet. He's a lot bigger than me. He doesn't even fit into my clothes. Latham got up on the stand. And that's not what Latham testified to. He goes, the government did not ask me to do a height assessment. He agreed that the poor posture, not measuring for height, was 6 feet and a quarter inch. But he also said that there is an error of margin, very small. And we talked about the black tape line. I asked him, and I go, how thick is that tape? And he goes, could be 1 inch, could be 2, could be 1.5 inches. Again, I wasn't asked to do a height assessment, and you can clearly see that Hakeem Robinson is taller than that. And then anybody knows, you get your height measured. When you go to the doctor's office, that little square is so small, so it forces you to put your feet together. You can get an accurate weight, you can get an accurate height. Again, they are trying to shrink Hakeem Robinson to fit. Stand up. You don't have to go based on that. You can look at him in this courtroom and make your own determination on the size of this man. Sorry, can we back up? And also the size of his feet. You can make that determination on your own. And when you do that, you can take a seat. Go back and look at the tiny little feet on the shooter. Latham said he would have the ability to be able to figure out the length of things. He spent nearly $100K on that guy to get up here and say, yeah, maybe. You don't throw in a few more dollars to get an accurate measurement of that foot? Let's go now to Sergeant Smith. February 5th, he's already committed on who it is. That's not an investigation. Literally days later, he sees an Instagram post. Now, what he says is, I screen recorded the Instagram post. We don't have the other Instagram stories to know what other things were out there. He just found one and he's like, this is enough. And he then commits to subpoena the meta records of my client. He had a print before that. We embrace that. That print was on that gun. It doesn't mean that he was ever inside of the car. And you know that he was in a music video holding all his buddies' guns. He was committed at that point in time. Print, post, he was done. His job was done. That's my case, but it wasn't enough. We got to build it a little bit more. Now let's compare this over to the other people that we know were involved. Varner, Butter, Blue, Abdul Sr., Abdul Jr., Torgon Williams, Natalie Bryan, Chris Brown. None of them posted anything. We use a phrase in these courtrooms every now and then, consciousness of guilt. That's consciousness of innocence. I'm going to post something, would be wildly, days later, wildly stupid. The only person that's going to do that is somebody who is confident in their innocence. I am using this because this, unfortunately, and I don't condone it. I'm not a drill rap fan. But it sells records. And it gets followers. But him co-opting a lifestyle of people that grew up around him as an artist doesn't mean that he's the one that committed it. I mean, look, country music stars talk about, murder. And look, I understand somebody actually died here. Rock stars will scream about murder. Other rappers will do it. We don't say that's a confession. But when it's a 21-year-old black kid from Jacksonville, it is. We're talking about the government and the way that they're trying to tailor the evidence. An opening statement. Mr. Cooper got up here and he showed you that post and he read it. I am never going to read that post. I don't have that right. First, they're assuming that's what it means. Right? Somebody could have a good day in court, post online, I killed it today. Right? So they want you to speculate that's what it means. But let's assume arguendo, that's what it means. So the government gets up here and they go a couple days later. A couple is 2, not 5. And then he says, getting his tired feet to try to say, he ran and then went and got a pedicure after that. Again, 5 days later, nobody else is posting stuff. Everybody was trying to get away with this crime, and apparently he just goes out on public to his hundreds of thousands of followers, JSO watching, and confesses. The problem is that, look, there's 2 ways that you can look at the world. You can look at it through clean windows or dirty windows. You look at the world through clean windows, you're looking at it objectively. You start looking at it through dirty windows, everything you see is dirty. And that's what former Detective Smith, now Sergeant, did. He committed, and everything he looked at for Hakeem Robinson was through dirty windows. He was a hammer. That kid was a nail. He didn't look at anything else, despite the fact that there is clearly motive of other people. Chris Brown. We're not arguing that Chris Brown is the one that committed. I don't come into court and make speculative allegations. There was more than enough to look at it. So, Chris Brown. Renata Boston says that the guy that comes out of the woods has shoulder-length dreads. Natalie Gant gave us that little tidbit as well, too. Oh, yeah, shoulder-length dreads. Didn't have shoulder-length dreads, not even close. Butter pecan skin. It's clearly more brown than it is my client. I can't say that I confidently know what butter pecan skin is. I'm thinking of ice cream, but I'm thinking that it's more close to this guy. But there's one other glaring issue with that. Rothermill case. The murder crew is Blue, Butter, and Brown. Crazy Chris. They literally have another murder case tied to Willie Addison. Smith gets up here and he goes, I don't even know his phone number. Talked about it in voir dire. You have to objectively investigate. You can't commit to a case, to a murder case, that is going to change the lives of so many people 2 weeks into the case. If he were looking at this case objectively, he would have looked into Brown. Oh, and don't forget, and I almost forgot this, Barner said Brown was involved. Now, someone would ask, well, why would Barner do that? I'm not asking you to understand the motives of a reliable hitman. I can't get inside of that guy's mind. I don't think any of us can. But is it crazy to think that in his mind he's thinking, first, I got to go with their narrative, but also, the more people I give them, the better my deal's going to be. Yeah, Chris Brown on 2 cases. That's not going to do much. But if you get more people, you can say, I gave you all of these people. There was plenty of people that had a motivation. Came out through Latham, it came out through Brown, it came out through other witnesses, that there was plenty of other people that would have been upset with what Charles McCormick did. None of them were looked at. None of them were evaluated. Instead, they spent $100,000 to say that it wasn't 2 other people that we were never arguing that it was. They never acquired any records of Chris Brown. His Instagram, his cell phone records, nothing. Same thing with Dominique Barner as well, too. They don't get his Instagram stuff, and he said that he was on Instagram. He used it to stalk his prey, and also his iCloud stuff. It's willful ignorance. Now, I'm not saying that Smith sat down and go, you know what, I'm going to jam this kid. I'm going to make a choice not to look at it. But he lacked all objectivity within minutes on the case and didn't look at anything else, wouldn't even consider it. Let's change gears now and talk about House of Pain. So we're going to go into the topic now and talk about all the communications and the cell stuff. The government, like they're trying to link, they're trying to shrink Hakeem Robinson, grow the shooter. They're trying to bridge a gap as well, too, with the cell phone communications. They're invisible dots, imaginary lines. They're trying to get you to speculate. Now, first, they're trying to both say that, Hakeem Robinson was involved, that 478-305-9583 number, that was his, that he was using it. They're trying to connect all of that. But that's not what came out. They'll argue it, but it's not what came out, and that's why we're going to go over it here. First, with respect to the House of Pain email account, and they're trying to say, well, there's selfies of Hakeem Robinson in that account. Now, we know that Blue was trying to be the manager of his son, especially when his career was taking off. And any Apple iPhone user knows that you can combine, you can share photo albums. You know what makes sense as well? Something that they haven't disproved because they didn't get any of the further records, that he's uploading photos to his father's account so that his father can manage his Instagram page, to do something as a manager to justify getting payment. I'm not saying that's what happened. I'm saying that there is a hole in there that they're saying, well, they're selfies. It must be his phone. It must be him that's doing it. They could have gotten to the source of it. They could have gotten the Gmail records for that account. They could have gotten Blue's Instagram account, literally HOP, House of Pain CEO. But they didn't. Some could say willful ignorance. I'm saying that it's Sergeant Smith, Detective Smith deciding. It doesn't matter. I'm committed on what it is. Now, there's anomalies within the cell communications. Now, they've never actually tied Hakeem Robinson to that 478-305-9583. Smith got up here and he tried to say, well, the IP address, the first 4. He's not an expert. We heard from 2 other cell phone experts. They were never presented with that information. He tried to say, well, the provider told me, that's hearsay, the provider told me that, it's the first four, not the last four, but I subpoenaed the wrong one. It was a 7, it was a 1, but yeah, it could be. Now, the government tried to say that based on what he said, it's a link. His words, could be. But even that is not even close to a connection. They had an FBI cast member agent up on the stand, didn't ask him any of those questions. You best believe that if they tied the IP address of that phone to my client, you would have had an expert from T-Mobile sitting in here going, here's your link. But instead we had Smith get up there and go, yeah, it could be. They're trying to blur the line, trying to connect him to the shooter and the phone to Mr. Robinson. Now, Blue says that he was worried about his son. Given his testimony, I don't think he cares about his son at all. But he says, you know what, I cared about my son. Whether it's him caring or not, there is not a single phone call to that number. You would think that if this is the phone that is being used in the commission of the crime, that somebody would be repeatedly calling it. Now they'll get up here and say, well, it could be a FaceTime call, we have no record of it, a data vet. Translation, they want you to speculate. They have never connected that phone over to the shooting. There are communications with one of the people much earlier, not during. There's a pin drop, could be in an area. They're wanting you to speculate. They need you to speculate because they have not made the connection. You remember, too, that they have the color-coded, they may show it to you here, that the red stands for that they even want to connect it before they've connected it, because the 478 number is in red, and so is my client's known 1595 number. They have it both in red. The interesting thing is that throughout the entire time of the commission of the crime, you see no red. It's everybody else. Now, mistakes and anomalies with respect to glaring mistake. The cast agent 7259, 7529, they admit it was a mistake, it wasn't entered incorrectly. Look, in other lines of work, could it be a scrivener's error? Oh, I thought you wanted it medium rare, not well done. In a murder trial, when you're trying to explain, to have a jury make a decision beyond a reasonable doubt, there's no mistakes. That was a mistake. And then we also have the anomalies with AT&T. And he said it, he goes, look, we can't, 95, I forget what the exact percentage was, but he's like, we don't use it because of the anomalies. But they still want you to trust some of the AT&T records. So, staying on the topic of the phones. Now, they brought up in the closing argument that Abdul Jr. had a phone that was registered to Darrell Watts, and that the 478 number was tied to Darrell Watts. What they're leaving out is that Ballew's main number was also registered to Darrell Watts. They also brought up this exhibit. It's a nice picture of Ballew. He looks like he's, indecisive, not the felon that he is. And they said, he's not going to send a message to himself. His email is literally right there, as if you're not going to see it. It's insulting. From his number, 2370, which is under Darrell Watts, sending it to 9583, and Abdul Robinson 71 at Gmail. Abdul Robinson Sr., born in the 70s, definitely not my client's email. They showed you this photo and made the argument he'd never send it to himself, where literally it shows that he sent it to himself. talk about the DNA and the fingerprints. We, of course, embrace there is DNA on a shirt. I think it may be out here, maybe over there, you know, with the white shirt. Doesn't prove that he ever wore it. We talked about it with the expert. If I were to take my client's handkerchief and wipe my brow, my DNA is going to be on it. And she also testified how that very easily could be the reason why there is a mixture, because they take a swab and they do the entire compartment, and that very much could explain, well, the t-shirt's sitting there, then we wipe everything, why there's a mixture and why it's so low. But we embrace that. His DNA is showing up on a shirt that's in the car and also on the dash. He was friends with these people. He rapped about the life that he lived. We are not denying that. He was around them. He knew them. Wasn't doing what they were doing, which is why he isn't covered in tattoos and bullet holes, because he's not living that life. The fingerprint, the music videos. So again, we embrace this, but none of that, and I don't need to go over it because I know you saw the testimony. But they both agreed objectively in their testimony, I cannot say he was ever inside of that vehicle. What we know is that his fingerprints are not in the vehicle, and there is not a 700 billion DNA reading of inside of the vehicle. There's a small mixture, and the DNA expert got up there and said, yeah, it easily could have been transferred by the t-shirt. The reason why the government's probably arguing it is because they know jurors like DNA and fingerprints. No, it's like that silver bullet, but not here. This means all it proves is that he knows people that we already agree he knows. The other evidence shows that. So don't let them sway you with the idea of DNA and fingerprints. At the same time, too, we have Chifton Hogan. If their rationale of anybody whose DNA is found inside of the car, well, you know, they must be involved. Chifton Hogan and Blue said, oh, yeah, that's a family member to some extent. Anything that supports our argument that if you know people, your DNA could show up inside of their vehicle. Talk about the witnesses in this case. Latham, the expert. The government, and I said this before, they paid $80K, $70K, $80K, I don't know how much his expenses were flying back and forth and lodging, to come in here and say, yeah, maybe. Meanwhile, all of the witnesses consistently describe somebody that's short and skinny. Then they arrest a guy who's 6'2", 6'3", 230 pounds. That's not how the truth works. That's how desperation looks. Latham up on the stand, and I asked him, and I go, can you exclude me without scanning me? And his answer is no. And from that you can take, there's nothing unique about what he's saying. He can confidently say, well, it's not Leroy Whitaker, it's not Dominique Varner, not being argued here. But nothing more. Now the government, in their argument, they have brought up this photo. Now we have to talk about Charles McCormick's height and weight. Latham said, well, you know, they provided the information to me and I do the analysis. And what they gave me is that Charles McCormick was 5'10". There's a problem with that though, because I had to bring it out through the medical examiner, and he goes, that's just an estimate. Post-mortem, there are differences. Could be 5'9", could be 5'11". Also, this person is wearing shoes. So when that was brought up with Latham, he goes, I was given 5'10". I then. They call the medical examiner, and the medical examiner tells you that's not, I can't say that's an accurate height. But they want to do this comparison in between somebody who's 5'10", and then over to the shooter. We know that Charles McCormick was 143 pounds. We know that definitively. When you compare that over to the person next to him, now, Charles McCormick is obviously turned a little bit, and they're not in the exact same posture, and I'm not denying that. But I could also make the argument that he's wearing darker clothes, which makes things look smaller, and the shooter is wearing light clothes, which make things look bigger. What you don't see is a huge difference, 100-pound difference between the two people. You see two skinny guys. Also, as for the height, yes, they are moving, they're dropped down. Let's do some math here. Hakeem Robinson, let's give him an inch, we'll say 6'2". Shoes, that's another inch. So he's at 6'3". Add then 3 inches on top of the head under that hood. That person's pushing 6'5", 6'6". If that were Hakeem Robinson next to Charles McCormick, 5'9", whatever it is, he would be way taller. But he's not. Again, the government's trying to shrink it. They're glossing over the 3 inches that Latham said, yeah, that could easily be 3 inches on top of his head. I submit to you it could be more. If Hakeem Robinson, those little tiny feet, there's no escaping those little tiny feet. You add an inch onto him, 6'2", 6'3", then whatever's underneath that head, that person is going to be a giant. You are not going to mistake that person for short and skinny, not a dozen times in a row. But they want to get up here and say, Charles McCormick, 5'10", despite what the witnesses said. Hakeem Robinson, 6 feet. They're tailoring their evidence because they know that the evidence itself, the facts, suck. Now, they may get up here and say, well, you know, we didn't need these witnesses. You cut a deal with violent felons and you don't need them? You cut a deal with Barnum, who's a reliable hitman. You only get the reliable hitman term if you have killed. We know that in these cases there's nothing to establish him as a reliable. In Rothermill, they killed the wrong person, an innocent guy in a bike. On this one, he gets caught, but he's a reliable hitman. Sounds more like he's a serial killer. They may get up here and say, well, you know, we didn't need these witnesses, our case was strong enough. Then why cut those deals? He could be out in a matter of years. Blue has a likelihood of being out in a matter of months. That's desperation. Don't let them get up here and say, well, we didn't need it. They did. That's why they cut reprehensible deals with violent criminals. There's an internal conflict with their testimony. Right? Now, they're felons. They're cooperating to get a deal. Let's put that aside for a second. So Barnard gets up on the stand and says in the Rothermill case, implicating Blue on how he could have been charged with much more than accessory, provided items. Blue got up there and he denied. So which one's lying? It's not our job to prove it, it's theirs to prove, okay, well this one's lying, but that one's telling the truth. As it stands before you right now, you have no idea. Schrodinger's cat. You have no idea who is telling the truth. But they want to put them up. They want you to trust these people, that they're pillars of truth. Because they came to them in handcuffs. Don't trust Johnny Shipes or Blue's daughter, who have no motive, and if anything, reasons not to come forward and testify. Mr. Shipes, Mr. Shapiro, because of his business. Blue's daughter, because she's basically saying that her father's lying in front of the judge that we'll be sentencing him. They have no motive. But no. Trust the people that came to us in handcuffs. Trust the people that we have on a physical leash to tell the truth. And again, we set aside the fact that they are murderers and felons. Don't let them get up here and tell you they're both telling the truth, that either of them are telling the truth when they didn't clear up that internal conflict in their own testimony. Now, Natalie Gann. They said in their closing argument, well, she had no motive. She absolutely did. You could see it on cross-examination. I could feel the breeze from her lashes fluttering at the counsel table as she was getting cross-examined about the motive that she has. Now, it's not about what this government thinks. So they sit there and smirk at you. It's not about what they think. It's about what that witness thinks when she's sitting on the stand. She knows Dominique Barner has implicated me in this case. I don't want to get charged. I'm going to do whatever the government says. Oh, and her husband sitting in prison being prosecuted by their office. It's about what's in her mind and the reason why she would have to tailor her evidence. Now, the government says, well, she didn't have all the details. She's older. She's not like the men she dates. She's smart. She knows if she commits too much, it could actually cause a problem. Oh, I don't remember what he was wearing. Because if she were to say the wrong thing, she's not usable. She hurts their case, potentially gets them mad, which is bad for her and her mind and her husband. The handguns. How would Barner know to say that the handgun was... Well, Barner is not... I'm not saying he's book smart, but he's definitely street smart. He knows that there was... Okay, and look, he was sitting on his case. He was getting prosecuted for months, looking at discovery before he ever made the decision to flip. He was arrested on the home invasion robbery. He had a whole bunch of records, and we're going to come back to that, on how he could have done what he did. But why would he claim that gun? Well, he knows that there's 3 guns in the vehicle. All right, one of them was used to commit a murder. The other one is a big machine gun. Yeah, that one's mine. Gave him musical chairs. He had to claim one. 3 people in the car, 3 guns. That one's mine. I'm not saying that the government, and if it's ever come off like this, I want to make this clear. I'm not saying that the government sat down with these witnesses and said, we need you to say this. Not saying that. Never would. But what I am saying is that they gave an opportunity to some really dangerous people. Dominique Barner is resourceful. He went on the court's computer system to stalk his prey, created fake Instagram accounts to figure things out in locations. He has a discovery on his case. We know that the first thing that was collected by Sergeant Smith were my client's meta records. The very first thing. Florida's a discovery state. This guy wants the government to be happy with him. They gave him too much of an opportunity. Now, the argument that we make over the recording, look, and we won't say it, the government has a right to talk to their witnesses. They're doing the work they need to do. They're talking to their witnesses. That's not our problem. Our problem is that the first and the second time they spoke to him, we have no idea what happened. Now, again, I'm not saying that these prosecutors told him what to say, but I do have any concern when the government is doing things behind closed doors, our government, without an ability to see it. And when they spoke to Dominique Barner the second time, Sergeant Smith told us they were leading questions. If you're getting the truth out of somebody, you don't have to lead them. You were driving the car. Hakeem Robinson was in the car. They're giving an opportunity for somebody to say the facts that they know the government wants to hear. And that's a problem that I have, that they allowed him that opportunity. Somebody that they knew was dangerous. Look, that serial killer has no problem taking a life. He has no problem lying to save himself. Sadly, we have no recording of the initial meeting. We don't know how he was able to get his facts straight, but I do know meta records are in the possession of law enforcement months before he cooperates. Florida is a discovery state, and he gets up there in another one of those times where we get new testimony. Oh yeah, he called Raekwon. You can clearly see that in the records. But what the government won't embrace is that my client's regularly talking to Raekwon. Somebody that he's supposedly supposed to have a problem with. What that proves is he doesn't have a problem with these people, which is why he doesn't have bullet holes in him, that he's not living that life, that he's not tatted up. And we also know, because after that, Raekwon Howard tried to kill people that we know were involved. Didn't go after the guy that he's talking to regularly and joking around with. So, it's very easy for somebody like Dominique Barner in a meeting. Dominique's sitting there. Did Hakeem make any phone calls in the car? In the questions being asked by a prosecutor that's holding a stack of papers. Barner's smart enough to go, yeah. It's that simple, and it's that easy for that to evolve into, yeah, he was talking to, yeah. And that's ruling out the fact that he has the records. He was involved. He's going to get some of the facts correct. But he's also resourceful, again, on hunting his prey. This time the prey was Hakeem Robinson. Now let's turn to Blue. Sat up here, fake tears, my son. Y'all saw it, there was no tears. He had that emotional pause. Yet he had no emotion when he was talking about the murder of his other son, Willie Addison. Abdul Robinson's daughter, no motive. If anything, reasons not to. I mean, of course, she doesn't want her brother wrongfully convicted. But she has reasons not to testify as well, too. Jonathan Shapiro, Johnny Shipes, no benefit, risk. Both of them gave a description of the height and the weight of Hakeem Robinson around that time. And it's inconsistent with what the government's saying. So, the government may get up here and talk about the fact that Barner and Blue are not sentenced yet, and that they don't know what they're going to get. That's by design. They got to make sure that they're dangling that carrot in front of them so that they do what they want them to do. It's also so that you as the jury don't hear what is potentially an offensive sentence that they get because of their recommendation. They want you to think, well, they could get life. There's no reason why they couldn't have been sentenced before coming in here. Now, one thing I want to go back on that I did miss. It's a really big point. And it's that both of them said, and government, I invite you to get up here and explain this one, that both of them said, Dominique Barner and Abdul Robinson Sr., have to say Ksoo to get the deal. Those are their words. I have to say Ksoo to get the deal. Let's talk about the jury instructions for a minute. I'm almost done here. So, when you go back into the jury room, one of the instructions you're going to get is weighing the evidence. And this is an opportunity for you to evaluate a witness's testimony. And these are things that the law in Florida says you got to be cautious of. We need to point this out to you because this could lead to a miscarriage of justice. Did the witness have some interest in how the case should be decided? Yeah, they're not spending life in prison. They're not getting prosecuted on multiple cases. Does the witness's testimony agree with the other testimony and other evidence in the case? I submit to you it doesn't. There's not massive conflicts, but there's definitely irreconcilable conflicts between their testimony. Has the witness been offered or received any money? We've already talked about Latham. Preferred treatment or other benefit in order to get the witness to testify. We are going to charge you with principle to murder. You're looking at life. You're a convicted felon 2 times prior. If you say what we want you to say, we'll recommend 72 months. Has any pressure or threat been used against a witness that affected the truth of the witness's testimony? You'll get out in 72 months, but you got to say Ksoo or otherwise you're looking at principle to murder. Did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? Yes. Has the witness been convicted of a felony? Both of them, yes. Just one of these is enough. They're hitting almost all of them. They're not just felons. They're not just convicted felons. They're felons who traded a story for a deal to save themselves. They sat down with the state and told them what they wanted to hear, not because it was the truth, but because it was the price of their freedom. It's not justice. It's bargaining with guilt. The government wants you to trust them over all of the other objective, unbiased, unmotivated witnesses. That's scary. You know, the government, they may get up here and talk to you about reasonable doubt and say, you know, look, my job is I got to get you in a boat across this river. There could be holes in the boat, but I've got to get you across the river. Now, I want to change and use that example, instead talk about waiver and vacillate, because that's what reasonable doubt is. You're standing there on the shore, you're looking at the boat. The boat, got some holes, some water's coming in. You're told that there are anomalies with the boat, it was manufactured incorrectly and there's problems. Any reasonable person's going to be sitting there going, I don't know. That's waiver and vacillate. But add on top of that, the two people that are captaining the boat are violent felons, and they're telling you, hey, this boat's fine. No reasonable person's getting into that boat, and that's what they're asking you to do. Let's talk about their burden of proof. I'm not going to go through this or spend much time on it, but just for the illustration of what we're talking about beyond a reasonable doubt. Everything else below that, strong belief, guilt likely, probably guilty, possibly guilty, none of that is enough for them to carry their burden. They have got to be able to rule out every other possibility. But the case that they presented to you, there's a whole bunch of other reasonable ones.
All right. The jury will listen to the instructions as I provide them to you, but you may proceed with argument.
They can't carry that burden. They have too many holes in their case, which is why they're not embracing the actual facts of the case and instead trying to mislead you. Now, whomever from the government gets up here and does a rebuttal, they may try to sway you with emotion, show you photos of Charles McCormick, talk about the tragedy. So let me save them that time and do it here for you. What happened to Charles McCormick, what happened to his family was tragic. No parent should have to bury a child. It's horrible. Convicting the wrong person doesn't fix that. It makes sure that the person that actually committed it, or other persons, go free. It doesn't protect us here in Duval County. Hakeem Robinson deserves better. The people of Duval County deserve better than Detective Smith getting up there going, yeah, that post was enough. The McCormick family deserves better than that. The emotion of this, the understandable emotion of this case, though, there's no place here. That's an attempt potentially to sway you into a verdict because the facts aren't enough to do it. So I'll save them that time of making that argument. In a short amount of time, you're going to be back in the jury room, you're going to be deliberating. You're going to be asked to make a determination whether Hakeem Robinson is guilty or not. Again, to quote his daughter, hell no. Thank you.